Hello, and welcome to another episode of the Up Your Assets podcast. I'm Ray Ferrara, CFP, and the founder and executive chair of Provise Management Group, LLC, which is an SEC-registered investment advisor. Today, we're going to talk about marriage and divorce. Yes, they do go together, unfortunately. In 2023, the most recent time period, reported by Center for Disease Control and Prevention's National Center for Health Statistics, there were 2,041,926 marriages, with 672,502 divorces, or 2.4 divorces for every 1,000 people. Interestingly, the U.S. has seen a decades-long decline in divorce, even as gray divorce among those age 65 and above have increased. Americans are marrying later and more selectively. While marriage and divorce come with an emotional element, the financial side can be equally devastating. To help us today, we've invited Ky Koch, who is a partner in the law firm of Older, Lundy, Koch, and Martino in Tampa and St. Petersburg, along with Clearwater and Newport Richey, Florida. He practices exclusively in the areas of divorce, prenuptial agreements, paternity, custody. Served on the Florida Board of Governors from 1990 to 1996 and on its executive committee for 2 of those 3 years. He's a former president of the Clearwater Bar Association and twice chaired a Florida Bar Grievance Committee. He served as chair for the 2nd District Court of Appeals Judicial Nominating Commission. Ky is a frequent lecturer throughout the United States at various family law continuing education programs. He's been honored by the Barney Masterson Inn of Court with its Professionalism Award, the Concarious Inns of Court John Linderman Award for Excellence, and the Clearwater Bar's Ralph Richards Award for Leadership. He was a founding member and 3 times past chair of the Tampa Bay Academy of Collaborative Professionals. Ky recently received his 3rd recognition by Best Lawyers as Lawyer of the Year. Ky, welcome to Up Your Assets.
I'm honored to be invited, Ray.
Ky, let's just jump right into it. And let's first chat about getting married. No one wants to plan for divorce on their wedding day, but with people getting married later in life, they often bring significant assets with them. We generally encourage our clients to seriously consider making a prenuptial agreement. Give us a little bit of explanation and explain why this can be a good idea and what is involved in the process.
I am seeing increasingly high numbers and new clients coming in asking for prenuptial agreements. And I think that's true throughout my profession. I tell my clients when they come in that they are about to embark upon one of the most difficult negotiations that they will ever experience. They are in a fresh new relationship, planning for a wedding, family members coming in, and at the same time, they are going to negotiate their divorce. A prenuptial agreement it's hard to sugarcoat it. It's nothing more fancy than a pre-negotiation for what happens in your divorce case. So one of the things that's very, very important under the law is full financial disclosure whenever you're getting into a prenuptial agreement. Every lawyer that's ever done a prenuptial agreement has told their clients, be very thorough in your disclosure. Overestimate the value of assets whenever you're called upon to guess as to the value of a business or certain possible inheritances. It's always best to overestimate rather than underestimate. And the reason for that is this. If you enter into a prenuptial agreement, then you get married, then you get divorced, if the financially disadvantaged spouse looks back at your financial affidavit and there is a value of $1 million on your business, which was 10 days later sold for $20 million, that spouse could attempt to set aside the prenuptial agreement, saying, if I'd have known the asset was worth that amount of money, I never would have entered into this deal. So anyhow, prenuptial agreements are difficult. There's all kinds of different ways to go about them. It can be the 2 fiancés discussing the terms at the kitchen table. It could be discussed between lawyers. It could be in a collaborative setting where everybody is present at the table and issues are addressed. So I guess bottom line in answering your question, Ray, is yes, I think are more and more prenuptial agreements being addressed right now. People are more attuned to it, and frankly, it does provide a good backstop against an ugly divorce.
Yeah. I think one thing to kind of add to that is, and through this whole process, particularly when maybe the prenuptial is being suggested by a wealthy parent who's trying to protect his daughter or son, as the case may be, or the couple is, no intimidation. You got to put everything on the table, make sure everybody's represented by lawyers. And you're so right. The last thing you want to do is think you have a prenuptial agreement, you underestimated or intentionally withheld information, because that's not going to play well in front of a judge.
Very true.
It's really important to consider just how compatible you are with your new partner. What is the full financial picture? Are you a spender or a saver? Will you combine money or do things separately? How will you manage debt going forward? Gosh, what is your philosophy on investing? Getting to know each other well at the beginning makes for a better marriage and thus helps avoid the costs, emotional and financial, of we've created two forms for those that are getting married and for those that, for that matter, are together today. The first is a premarital financial planning worksheet, and the second is a financial compatibility questionnaire. So if you'd like to get a copy, just send me an email at ray@upyourassets.org and be happy to send it to you. And again, that's ray@upyourassets.org. Ky.
It is important that both sides be represented by counsel. And many times I will tell my client, don't hesitate to pay the other lawyer's fee. You will get it back in spades if there is ever a divorce. It is a great prophylactic to the validity of a prenuptial agreement for both sides to be represented by counsel. And unfortunately, my memory has left me. There was another point I was going to make, but I'll get back to it, I'm
All
sure.
right. Well, probably the most basic question I can ask you is how do I find a competent and ethical attorney to help me? Where do I go? Not the yellow pages, I'm sure.
Yeah, I wouldn't recommend the yellow pages. Word of mouth, it's the same old thing for just about every profession. Word of mouth is the best way to find a professional to assist you because you're getting it from a trusted source, somebody that's been through the mill, somebody that's been represented by or at least familiar with that lawyer. There's also other telltales like Google reviews, board certification. What is that lawyer's involvement in the legal community and in the local community outside of the law? I think that tells a lot about a person, how much they've been involved in the community and the betterment of the people around them.
Okay. So referrals, and it really is, who do you know? And talk to friends who might have gone through the process, talk to your estate planning attorney, your CPA, perhaps your financial planner. All of those people ought to be able to give you some type of a referral to someone to help you with these family matters. Well, Ky, let's assume that I'm thinking about a divorce. For full disclosure, I'm not after 55 years of marriage. What are the options? As people prepare for divorce, what one thing or two can they do to best prepare for the ultimate division of their assets?
I think the best thing anybody can do to prepare for a divorce is seek therapy. Get yourself right. Attempt to get drawn into the emotionality of the divorce case. Get yourself focused on being rational, reasonable, fair. Those kinds of things I think are very important to get yourself ready for a divorce. It's a tough process, and there is a whole wide spectrum of available processes for divorce. At the far end is 2 years from now, several $100,000 from now, the guy or gal in the black robe is going to tell you what happens to your money and your kids. That is never the right way to go, in my opinion. The lawyers are going to win, the clients are going to lose for the most part. At the far end of the spectrum, on the other end, is sit down at the kitchen table and with your spouse, draw out an agreement, take it to a lawyer and have a lawyer draw it up. Lucky for me, that never happens. Never.
Hmm.
It happens in less than 0.001% of all cases. And the reason is back to what we talked about a moment ago, and that is people get sucked into the emotions, and the resentments have built up over the years, and the guilt issues weigh heavy on one spouse or another. And seeing through the emotions is not something that people are easily geared to do.
Yep. So, equitable is one thing, fair is the other. And just because something's equitable doesn't necessarily mean that it is fair. And the example I always try to give people is, let's suppose that there's $500,000 in a 401k, and there's $500,000 in assets that are invested in the market, where the appreciation is a couple $100,000. You give 500,000 to one, give $500,000 to the other. Seems like it's equitable. It is 500,000 to each, but it's not fair because of taxes. So, what role does tax play in the division of assets?
Tax plays a huge role in the division of assets. And you talked about the difference between fair and equitable. CPA that I do a fair amount of work with once said, fair is something that comes to town once a year. Equitable is what's going to happen to your assets in terms of its division. But there's recently been a breakthrough in Florida. There's a brand new case out of Miami, I believe it is, where an appellate court said that in every divorce case where assets are being divided, those assets are to be tax impacted before division. So what that means in your scenario is the investment account, the basis would be determined with a hypothetical sale that day, and the total amount of the account would be reduced by the tax impact of the capital gains. In the 401k, it's a bit different in that you're guessing when that tax would be occurring. So somebody might not draw on it for 20 years. And what's the tax rate at that time in 20 years? And how much is their income in 20 years when they start to draw? So it's a total guess as to what the tax impact would be. What happens in our profession is it is very standard for somewhere between 22 and 25% is assessed against the value of 401ks and IRAs to tax impact them for distribution.
So now we've got equitable, and now we've got to fair because we've essentially paid the taxes on it. So again, what's equitable may not be fair. What's fair may not be equitable. So you want to always look for something that's fair and equitable. Well, Ky,
Correct.
you have to get paid for what you do. So if I was hiring you to help me, what kind of costs, billing, and other expectations should I have?
Well, there's a very wide range of attorney fees that are out there. As a matter of fact, I was just involved in a case where I did kind of a limited study of that. In the Tampa Bay area, lawyers' fees range between $225 an hour all the way up to $900 per hour.
Wow.
So those of us that are old and crusty and have been doing this for a long time tend to charge a bit more because hopefully our expertise will assist clients in facilitating a settlement, and we've learned maybe a trick or two of the trade. But it depends on the complexity of the case to determine what type of qualifications you're looking for in a lawyer. So child custody is a very, very expensive endeavor when there's a fight about it in any way. Relocation, when one of the parents wants to move out of state with the kids, are some of the nastiest, most expensive fights I've ever been in my life. And by the way, one of the proudest, happiest days of my practice is when I gave up doing custody work. It's way too hard.
Yeah.
But
I imagine
anyhow,
it takes a pretty emotional toll on you as well as the lawyer.
it's hard. It's hard. You're fighting about the most important issue that anybody could ever fight about, and that is their kid.
Yep. So,
So anyhow,
we talked earlier about the prenuptial and maybe potential inheritances. And one of the reasons we talked about the forms that we have for people is everybody approaches money in a different way. And it is said by many psychologists that couples are willing to talk more about sex than they are about money from time to time. So, how How are the assets and the debts? How are they valued and divided? You touched on that a little bit, but let's talk a little bit about the debt side of it as well. I mean, a simple thing would be like a mortgage and credit card debt. How is that handled?
So a mortgage would be netted out against the value of the home, along with any tax consequence of a potential sale. So assuming the home is worth $1 million and there is a $500,000 mortgage against it, million less 500,000 is a $500,000 asset that's going to be given to either the husband or the wife or sold and split. Sell and split's easy because you don't have to guess what the value is. You don't have to guess what the tax impact is. When one of the parties gets it, the tax effect comes into play along with the netting it out against the mortgage. So in that example, the IRS provides that there is an exclusion from capital gains when you sell your primary residence. Primary residence, not a rental property, not a vacation home, primary residence. And each person in the marriage has $250,000 of sale proceeds excluded from capital gains. So in the scenario I gave you, even if the basis in that house were $500,000, there would be no capital gains tax. The other debts, credit card debt is always an issue. There's always complaints, it seems, between spouses about he's spending too much or she's spending too much, and they run up the credit card debts. And, as a lawyer, the first thing I want to tell these people is get rid of this debt, pay it off. You're paying 18% interest. It's enough to choke a horse. And paying off debt is, by the way, one of the things I think people can do to properly prepare for divorce, because debt can bring you down in a lot of different ways. But fighting out who's got to pay it in a divorce case is never productive.
So, Kai, I think that's great advice and certainly great financial planning advice for anybody. It always amazes me the number of people who come to see me who are carrying $20,000 of revolving credit on a credit card, and they're sitting with $100,000 in a savings account, maybe in today's world earning 3.5%. And they don't understand that delta of earning 3.5 and paying 18 to 20%. So
Makes
paying off
sense.
debt is a good thing all the way around. So
Mhm.
let's talk for a minute about alimony. Is alimony always involved, and then how does it determine what the amount of that alimony is going to be, and for how long is it going to get paid?
So alimony is one of the more difficult, other than child custody, obviously, one of the more difficult issues that we deal with because there is no bright line guidance. There is an acronym in the world of divorce, PEACE, PEACE, ironically enough, and that is the order in which issues are to be determined in any divorce case. For settlement or for trial, this is the order in which issues are resolved. PEACE, parenting issues; E, equitable distribution; A, alimony; C, child support; E, everything else. So you decide the parenting issues first because the other issues flow with that. Who's going to get the house? Is there going to be alimony? How much is the child support? Things like that. Parenting issues first, equitable distribution second. Who gets what? The reason that's important is if let's assume a traditional relationship and a homemaker wife and a CEO husband, he's making a whole lot of money and they divide up a whole lot of money. The wife gets a check for $10 million. She may not need alimony after that check. She's going to be imputed earnings on that amount somewhere in the neighborhood of 4.5% per year. So you get $10 million, 4.5% is $450,000 a year. She may not need alimony, but there are other considerations in alimony than just that. So we had a law change in July of last year, July of
This
2020.
guy, forgive me for interrupting, but since people all over the country are going to hear this, you're going to be speaking about a very specific case here in Florida.
Yes, I'm talking about Florida's new law came into effect July 1. Thank you for reminding me of that. So in Florida, we got rid of the idea of permanent periodic alimony. It doesn't exist anymore. And it is now replaced with durational alimony, which is a set number of years in a set amount. And there are now short-term, mid-term, and long-term marriages in Florida, 0 to 10, short-term, 10 to 20, mid-term, 20 and longer, long-term. And the length of alimony is determined by whether you're in a short, mid, or long-term relationship. 50% of the duration of the marriage if it's short-term, 60% if it's midterm, 75% if it's long-term. And we have a new formula of sorts to decide what amount alimony could be awarded in. It is going to be somewhere between $0 and 35% of the delta, the difference between husband's income and wife's income. Now, so that's a max. It's not the amount to be set, it's the max. As is the duration, it's a max. So somewhere between 0 days and half the length of the marriage, 60%, 75%, and the amount somewhere between 0% and 35% of the difference. So this has been somewhat helpful, but still there's a wide disparity between the low side and the high side, as you can see.
Absolutely. You know, often when we're dealing with clients who are going through a divorce, we really try to encourage the avoidance of alimony wherever possible by perhaps a larger asset distribution. Our experience has been over the years that, you know, every time that person writes that alimony check, there's that bitterness all over again. Every time that check's a few days late, there's that bitterness again. And it's just constant 12 times a year for whatever number of years it might be. So one thing to consider is making a larger property settlement in order to avoid alimony altogether.
Absolutely great point. A couple of issues that are involved in that are the psychological advantage that the non-moneyed spouse feels in receiving a check every month so that he or she knows they can pay their bills is oftentimes more important to them than money in the bank. The other part of the wisdom behind your advice is an alimony award is by its own definition modifiable. So if you enter into an alimony situation and 5 years from now, 3 years from now, 10 years from now, there is a change in circumstances, either side can come back and ask to change it. You know, one of the advantages of getting divorced is to get the lawyers out of your veins and avoid that eventuality down the road. I tell clients all the time, look, there is a huge advantage in getting this in a lump sum, not having to pay periodic alimony. You don't want to be coming back to court later to fight whether it should be more or less.
Exactly. Well, let's switch from alimony to child support. How does that come into play? What does a court or the couple, what should they be looking at as far as that's concerned?
So child support and child custody are never able to be addressed in a prenuptial agreement. You can spend 100 pages of a prenuptial agreement addressing child support and child custody, and it's unenforceable. And the reason for that is because you are prejudging a future event that relates to the welfare of a child. So that's number one. Number two, child support is a direct calculation based upon income, him and her. It's simply a plug in the numbers. Variables are incomes, number of overnights of time sharing and visitation, healthcare, and daycare. Those are the variables. It's just to plug in the numbers, and it spits it out, and judges are duty bound to follow it. One of the major variables with child support that's not in those calculations is private school, is uncovered medical, dental, ocular, pharmaceutical, and orthodontia expenses. A teenager's car. God knows car insurance is expensive for a 16-year-old. So all of those factors are not in that formula and are separately addressed.
So let's say that I'm getting ready to be divorced. I may have even come to you already. How can I protect myself financially, during this process? One spouse worried about the other running up a bunch of bills to have a whole lot of debt, buying a whole bunch of things, going on a big vacation while you're going through the process. How does each side protect themselves?
Well, it's a great question. One of the things you don't want to do at the outset of a divorce is start setting fires. And there's nothing like a fire starter than canceling a credit card. So I tell my clients, sit tight, Let me work with the other lawyer. Let me see what I can get done in terms of an agreement. I know you're worried that your husband's spending too much on his credit card. Let's sit tight right now. Let me talk to the other lawyer. Let's not start any fires. See if we can work together to start solving some of these problems. Another possibility is turn down the credit volume. A credit card that once carried a $20,000 limit, maybe drop it down to 7,500. But don't put your spouse in a situation where he doesn't have the ability to charge and to live and to buy gas, and for some of us get our hair cut. So those kinds of things are issues that at the beginning of a case I think are really important for a lawyer to consider and properly advise their spouse on, let's not start a fire here. Let's try to work through these issues cooperatively.
What about the house, the home? Should one person move out? Is it a good idea to move out? So how do you make those decisions?
The biggest issue for me is personal safety. If somebody is not feeling safe in the house, I tell them, get out now. And even on the other side of it, if my clients have been accused of domestic violence, I'm going to tell them, get out and get out now. There is, in Florida at least, no such thing as abandonment. If you leave your house, you have given up no rights. Everything in it you still have the same right to. The value of the home you still have the same right to. You can still get the home and distribution of assets. So if there's a personal safety issue, I'm always advising people to get out. Very little is going to be, there's not going to be much good by people staying in a home together while they're getting a divorce. It's only going to be bad. So there are situations, though, where I'm going to tell people to stay in the house. It all depends on the financial circumstance, the temperature of the marriage, how high the emotions are. Kids play a factor. Sometimes dads, for instance, don't want to move out because they've got only a few last months of being able to wake up with their kids, put them to bed, and that's difficult on us. So it depends, but generally speaking, moving out of the house causes you no harm. You're not giving up anything, no such thing as abandonment, and just make sure that you continue to be the best parent you can be.
So, Ky, most of what we've talked about up to this point is kind of talking about what has been the traditional divorce, going to court, working through the process, maybe sometimes months, and as you mentioned earlier, unfortunately, sometimes year. But you've been a real pioneer and champion about the collaborative divorce process. Take us through that process, how it's different, and why it is beneficial for couples to consider doing that.
Well, I'm a huge believer in collaborative divorce, Ray, and it's probably an invention from 12 to 15 years ago. A lawyer in Minnesota decided, all this litigation and judges and stuff only serves to splinter families and to cause further resentments and emotions. And these parents are never going to be able to sit in the same pew at their kids' because of all the animosity that goes on during the course of the litigation. So he invented this collaborative law process. It is a contract between the two spouses that says we are not going to court. We're going to hire lawyers that have been collaboratively trained. We're going to hire a CPA to come in and manage the numbers. We're going to have a shrink come in who's going to manage the emotions and the communication. And the six of us are going to sit at this table for a series of 3, 4, 5, 6 meetings, separated typically by a month each, where we will chip away at the issues, resolve them one by one, with the idea that you're putting building blocks on the table until you get to a final agreement. It is polite, it's respectful, it is organized, it is efficient in that it can solve problems in real time. Truly, these four people, the CPA, the shrink, the lawyer, and the lawyer, are on a team whose job it is to get the two spouses to the finish line. Our job is to help them settle their case. So if, for instance, the other lawyer calls me and says, little Johnny got hurt last night at Dad's house, and Mom is really upset about it, and we need something done, I can get on the phone and deal with these issues immediately, as opposed to litigation where you're waiting 3, 4 months to get into a courtroom. So
So
collaborative is effective. It typically runs 5, 6, 7 months in length. There's shorter and there's longer. It all depends on what issues the two spouses are unable to agree on. And for the most part, they control the process. They're going to control what agreements are made. They're going to control the calendars and when we're having meetings. They don't have to worry about a judge being on vacation and not having hearing time for 4 months. And this team is truly a backstop and support for them in every respect as they're going through this emotional time.
So, Ky, you said it's a contract between the two parties and the lawyers. What happens if it doesn't work out? What's the recourse, or what are the implications of that?
Well, again, good question, because that's an important hook in this process. The collaborative law participation agreement, the contract that they sign, says that if anybody goes to court, all the lawyers are fired and the two spouses must go find new counsel. That's the hook that makes this process work, in my opinion, because it vests us, the lawyers, in the settlement process. We don't want to lose a client or lose a case or fail at the collaborative approach. And it vests the clients even further in the process because they've got to go get new lawyers. They've got to tee this up. They've got to start anew in heading down the litigation process. And they spent time and money going through trying to get things settled that's pretty much going to be down the drain.
And then you got a new lawyer, and you got to bring them all up to speed. So it is truly wasted money. Well, let's suppose everything works out, either whether it's in court or collaborative, et cetera. I'm now divorced. The papers are signed. What's the last piece of advice that you give a client once the divorce is finalized?
Well, I give them several pieces of advice. One is you need to find a financial advisor with whom you have a good connection and a high level of trust, because what you do with this money you're receiving is going to direct the rest of your life and the comfort that you feel in the rest of your life. Secondly, I advise them to continue to be the best parents they can be. And if they need therapy or they feel as though their minor kids still need therapy, follow up on that. Thirdly, I advise them, and this is during the settlement process as well, and when you settle a case, everybody compromises. That's how it happens, which by definition is nobody's winning. Everybody's giving up some of the things that they cherish and that they want. So compromise is the order of the day. If you cannot accept this compromise as being fair, as being equitable, as being durable to permit you to live the rest of your life without looking back at this horrible experience, that settlement makes no sense.
Well, those are all good pieces for the folks to have. And, hopefully at the end of all of this, both sides find some peace and some happiness that they didn't find in the marriage.
Yes, true.
Ky, thanks very much for being with us here and having a chance to talk about divorce for our listeners at the Up Your Assets podcast. We'll be back in another 2 weeks with our next edition. Ky, again, want to thank you very much for being with us. And in the meantime, go out there and up your assets.
This has been another edition of the Up Your Assets podcast, hosted by Ray Ferrara, CFP founder and executive chair of Provise Management Group, LLC. The preceding presentation was for general information purposes only and not personalized advice. Seek out a professional before making any financial decisions. Additionally, no guests pay to be on the show or are paid to be on the show. The opinions expressed are their own and not the hosts or the show.